Good afternoon. My name is Abisoye Abibat. And on today's episode of What the Law Says, we'll be discussing on custody of children after divorce. Custody of children after divorce is one of the most important issues in family law. In Nigeria, the welfare and best interest of the children are the overriding considerations. Courts have consistently held that the best interest of the child is paramount. So let's start with the definition of custody itself. Custody is the legal authority granted by a court to a person to have the care, control, upbringing, and supervision of a child after divorce or breakdown of marriage. It includes two parts. There is the physical custody and there is the legal custody. Physical custody is where the child will be living, while the legal custody is having the authority to make important decisions about the child's well-being, education, religion, and so on. Therefore, we have different types of custody. We have the sole custody. The sole custody is defined as where one parent has primary custody and the other parent has visitation rights. Then we have the joint custody. For the joint custody, both parents has responsibility. The child may live with one parent. Decision makings are made by both parties. We also have the split custody, and in that custody, different children stay with different parents. We also have the third party custody, and in this scenario, the child or children lives with the grandparents or relatives of the parents, and this happens in exceptional circumstances. There are also laws that regulate custody in Nigeria, and the major ones are the Matrimonial Causes Act and the Child Rights Act. In the Matrimonial Causes Act, Section 71, 72, and 73 defines how the courts will regulate how custody is being granted. And in the Child Rights Act, Section 1 reinforces and explains that the best interest of the child are always the primary consideration in custody being granted. And this is the foundation of all custody decisions making in Nigeria. Also, Section 69 of the Child Rights Act and also Section 14 also gives more on what should be done for the custody to be granted. Then we are moving on to the question, who gets custody? There is no automatic rule that the father gets custody or the mother gets custody. There are several considerations that the courts will have to look at before custody can be granted. The first one is welfare principle. The welfare of the child is the overriding consideration of all other considerations, because the courts will ask questions like, where will the child develop better emotionally, morally, physically, and educationally, and not who is the richer parent. The age of the child is also considered. Young children, especially infants, always remain with their mother because of breastfeeding, maternal affection, and emotional attachment. However, this is not absolute. Also, the wishes of the child is always considered also, but this only occurs where the court feels the child is mature enough. A poorer parent can receive the custody if they provide a more stable and caring environment. So the court considers the conduct of the parents, whether either parent is violent, neglects the child, is mentally unstable, abuses drugs, and so on. There are different considerations that will be looked into before custody can be granted, and this can be seen in different cases, such as in the case of Williams versus Williams and also in the case of Alade versus Alade. So on behalf of everyone at Natha-Alade and Partners, we say thank you for joining us. We hope today's discussion was informative. Until next time, my name is Abisoye Abibat.